This is an open meeting of the United States Securities and Exchange Commission on June 30th, 2010. Today, we consider adopting rules that would significantly curtail the corrupting influence of pay-to-play. Pay-to-play is the practice of making campaign contributions and related payments to elected officials in order to influence the awarding of lucrative contracts for the management of public pension plan assets and similar government investment accounts. Pay-to-play distorts municipal investment priorities as well as the process by which the investment managers are selected. It can mean that public plans and their beneficiaries receive subpar advisory performance at premium price. The cost of this practice is borne by retired teachers and firefighters and other government employees relying on expected pension benefits, or by parents and students counting on a state-sponsored college savings account. And ultimately, this cost can be borne by taxpayers who may have to make up shortfalls when vested obligations cannot be met. An unspoken but entrenched and well-understood practice, pay-to-play can also favor large advisors over smaller competitors, reward political connections rather than management skill, and, as a number of recent enforcement cases have shown, pave the way to outright fraud and corruption. There should be no place for such practices in an investment advisory industry subject to high fiduciary standards. The selection of investment advisors to manage public plans should be based on the best interests of the plans and their beneficiaries, not kickbacks and favors. The rules we consider today will help level the playing field, allowing advisors of all sizes to compete for government contracts based on investment skill and quality of service. When the Commission first considered a proposal to curb advisor pay-to-play practices in 1999, it was in part motivated by widespread media accounts of dubious arrangements between fund managers and municipal officers. In the years since, the amount of money at stake and the incentive for inappropriate conduct has ballooned. Public pension plans now represent 1/3 of all U.S. pension assets, with more than $2.6 trillion in assets under management. Additionally, state-sponsored higher education savings plans, commonly known as 529s, now hold approximately $100 billion in assets. And these plans were in their infancy when the Commission first took up this issue in 1999. The agency has brought a series of enforcement actions charging investment advisors with participating in pay-to-play schemes. Most recently, we brought a civil action involving allegations of unlawful kickbacks paid in connection with the investments by the New York State Common Retirement Fund. In recent years, civil and criminal authorities also have brought cases in California, New York, New Mexico, Illinois, Ohio, Connecticut, and Florida, charging the same or similar conduct. Our recent cases may represent just the tip of the iceberg. I fear that many other efforts to influence the selection of advisors to manage government plans pass unnoticed, or, though highly suspect, cannot be proven to have crossed the line into actionable behavior. Not surprisingly, parties to these suspect transactions take care to blur their motives, to hide their actions, and to conceal their connections, making it difficult to prove a direct quid pro quo or an intent to curry favor in a specific case. The prophylactic rules we consider today are designed to eliminate this legal and ethical gray area. The rule we're considering today has 3 key elements. First, it would prohibit an advisor from providing advisory services for compensation, either directly or through a pooled investment vehicle, for 2 years if the advisor or certain of its executives or employees makes a political contribution to an elected official who is in a position to influence the selection of the advisor. Second, the rule would prohibit an advisor and certain of its executives and employees from soliciting or coordinating campaign contributions from others, a practice referred to as bundling, for an elected official who is in a position to influence the selection of an advisor. It would also prohibit solicitation and coordination of payments to political parties when the advisor is pursuing business from public entities. Finally, and very importantly, the rule would prohibit an advisor from paying third-party solicitors who are not regulated persons subject to prohibitions against making contributions. Such regulated persons would be limited to registered investment advisors and to broker-dealers, subject to pay-to-play restrictions. Third-party placement agents have been involved in some of the most egregious pay-to-play activities in recent years, and their activities should not continue unabated. The approach we are taking is a strong step toward eliminating the corruptive influence that can result from the use of third-party placement agents. It will greatly improve the status quo by banning payments to third parties who solicit government clients unless they are regulated persons subject to pay-to-play restrictions comparable to the rule we're considering for adoption today. This approach provides far greater protection of public pension plans and their beneficiaries than is currently the case, as third-party placement agents come under the regulatory umbrella and for the first time become subject to meaningful federal pay-to-play restrictions. This approach should effectively eliminate the opportunity for abuse that currently exists from third-party placement agents. However, if the Commission determines that third-party placement agents continue to inappropriately influence the selection of investment advisors for government clients, even under our enhanced rules, I expect that we would consider the imposition of a full ban on the use of third parties. Let me end by underscoring once again why we are here today. Pay-to-play practices are corrupt and corrupting. They run counter to the fiduciary principles by which funds held in trust should be managed. They harm beneficiaries, municipalities, and honest advisors, and they breed criminal behavior. I hope my colleagues will join me today in striking a blow against a practice that has no legitimate place in our markets. Before we hear more details about the rules we're considering for adoption, let me first offer my thanks to the individuals representing a cross-section of 4 divisions and numerous offices for their help in bringing to the table today a truly thoughtful, impressive, and potent example of rule writing. In particular, let me thank Buddy Donahue, Bob Plays, Sarah Bassine, Dan Call, Matt Golden, and Melissa Roverts in the Division of Investment Management, Charlotte Buford, Glenn Gentry, Elaine Greenberg, and Mark Zahner in the Division of Enforcement, Paula Jensen, Lourdes Gonzalez, Linda Sundberg, Martha Haynes, and Mary Simpkins in the Division of Trading and Markets, Henry Hu, Bruce Krause, Harvey Westbrook, and Woodrow Johnson in the Division of Risk, Strategy, and Financial Innovation, Jean Golke in the Office of Compliance, Inspections, and Examinations, Lori Schock, Rich Ferlato, Owen Donnelly, and Mary Head in the Office of Investor Education and Assistance, and David Becker, Meredith Mitchell, Lori Price, Lynn Taylor, Sarah Buscher, Jake Stillman, Mark Pennington, and Jeff Berger in the Office of the General Counsel. And let me turn it over now to Buddy Donahue, who will present the staff's recommendation.